Good afternoon, everybody. My name is Merrick Green. I'm the founder and managing partner of General Counsel PC. Here with me today is Joanna Foard, who leads our family law practice. And we're excited to go through our 20 family law questions, our Ask Joanna webinar. We've done this once or twice in the past, and I think it's been fairly well received by everyone, so we're pleased to be able to do it again today. Any initial thoughts or comments or welcomes?
Welcome, everybody. Thank you for joining us. Whether you're popping in on your lunch break, can stay the whole time. We really put these webinars together to put, top 20 questions, and we have a lot of materials on our website. So if you have any questions, if anything, sparks another question for you, we have a chat feature, but also feel free to reach out to me. I'm happy to talk to you and provide a complimentary consultation if you mention that you joined the webinar.
Well, that's a nice little perk. I'll just say this quickly and we'll go into this a little bit more. Just a quick accolade for Joanna. As I've had clients here at the firm. The firm's been around for 17 years and had a number of people that have worked with her in the past year. And without exception, each of them comes to me unsolicited, just sort of saying, Merritt, thank you. Joanna's wonderful. So if you're looking for an attorney to help you with a custody matter or divorce or anything along those lines, I think you'd be in very good hands with Joanna. But with that, why don't we go through? And if you have any questions, please use the questions tab on the GoToWebinar toolbar. So with that, just quickly, a little overview about General Counsel. The firm was founded in 2004. Initially, we really represented businesses. So we were the outside general counsel to businesses and nonprofits. In the past few years, we've added additional practice areas to include family law and estate planning. So we really try to be that one-stop shop for small, medium-sized businesses, nonprofits, and their owners and executives. So with our estate planning and family law practice. Here's a little background on Joanna. A lot of this is also available on our website, so you can look at it there. One thing we always need to highlight is on AVO, which is a lawyer directory website you can go to. She just has exceptional reviews, more reviews, quite honestly, than I think I've ever seen from any other attorney out there. So worth looking at again if you're considering and looking for a family law attorney to work with. Here are a few of the reviews that I think these were the most recent reviews from when I first put this together a few months ago. But again, highly encourage you to go back, look at AVO. As someone says here, she was awesome. So Joanna has great reviews and people like her. Before we jump in, Joanna, do you want to add anything else? Do you want to, affirm how wonderful you are, or do you just want to take your client's word for it?
Stop, Mary. I really appreciate that. And there are lots of areas of law that interest me, but I've dedicated my practice to family law. It's certainly not, I don't close my laptop at 5 and not think, I'm always thinking, trying to be available to my clients. And I find it to be the most satisfying area. So, when people take the time to either compliment me or leave a review, it's just, I'm so grateful because I really put a lot of myself into my work. So it's wonderful to see and to hear those things. Before we get started, I will say that none of this is to be interpreted as legal advice. This is just like general questions that we put together. And, your case could be similar, but not exactly the same. So it's not necessarily, if I'm saying something, that is the way it should be. And also something that I haven't pointed out before that I'd like to say is that this webinar is specifically tailored to Virginia law. And Merritt and I might be putting together something maybe for Maryland. I'm going to be working on some Maryland material similar to the Virginia materials that we have on the website. So if you have questions regarding Maryland law, let me know too. But this particular set of questions will be focused on Virginia law.
Yeah, the Commonwealth of Virginia.
The Commonwealth, not the state. I'm new here.
Sorry, inside joke, everyone. Virginia is a Commonwealth. It's not referred to as a state. and Joanna once or twice referred to it as a state in prior webinars. So she is not perfect in all ways.
No.
All right, well, with that disclaimer and jokes out of the way, and we all know that it is a Commonwealth, let's proceed from there. So, number one, my spouse and I have not been getting along for the past few months, and I feel like we're both contemplating taking the next step, but neither one of us has actually made the first move. What are my options, and how do I start the process thinking about divorce?
Well, a good place to start would be to either pick up the phone or send an email and get a consultation set with an attorney, because based upon your facts and circumstances, you can discuss, there are certain requirements before you can actually file, whether or not you feel ready. You might not meet the requirement to file. Also, there are other methods such as a postnuptial agreement. If you're already married, a prenuptial agreement, which is a document that's created before you get married, would no longer be available to you. But a postnuptial agreement is something if you want to remain married and not separated, but maybe you and your spouse want to come to decisions regarding the assets and liabilities of your marriage, should you in the future decide to go for a divorce. So there are lots of options, and you can talk through those.
I always think that's one of the best reasons to contact an attorney, is just to get information and understand what the options are. I wasn't even thinking that, post-nuptial agreement, the first thing I was thinking of, and the answer was, all right, what are your circumstances? Do you have children? Do you not have children? What are the assets you have? Are your assets held in a trust, or do you hold them individually? Do you have pets? Do you have fancy artwork? Was one spouse working and the other spouse not working? Are there special needs kids? There are all these circumstances. Did one spouse get a large inheritance and the other one not? Do you have a summer house, et cetera, et cetera? There are all these different circumstances that you need to sort of think through, before you take that next step. And just a quick plug for our estate planning practice here. Quite honestly, if you're thinking about getting divorced, or perhaps you're starting down that path and you get separated, I always think it's a good idea to sort of at that time perhaps update your will, because the last thing you want to do is be separated from your spouse that you now no longer like because he or she is living with some 22-year-old in Tahiti, and then you're walking down the street, get struck by lightning, and that spouse gets all of your money and life insurance and everything else. So something to think about. Let's keep moving on that rosy note. Number two, I'm in the early stages of a divorce and I keep hearing about mediation, but I don't know what mediation is. What is it? Do I have to do it? And who pays?
So here in Virginia, mediation is not mandatory. So in some states, in order to proceed forward, if you were unable to come to an agreement between the spouses, before you can go to trial to the judge, you have to mediate. This is not a state that requires that, Commonwealth. So essentially, mediation is a voluntary process. And I always recommend having an attorney, both sides. So it would be one party and their attorney, the other party, their attorney, and a mediator. And a mediator is a neutral third party, usually a family law attorney. A lot of times it's a retired judge, honestly, someone that has that viewpoint from the bench that's able to not provide legal advice, but kind of like I say, keep it real, because people oftentimes, it's a very tense situation when you're going through divorce, or it can be. And in mediation, oftentimes it's good to have a neutral third party with that experience that can provide some real world, just like point of view. And the goal of mediation is to end up with a marital settlement agreement. And in that document, you would distribute the assets and liabilities of the marriage. If there are minor children involved, you would come up with a custody plan. There is a charge. Obviously, each party would have to pay for their attorney's time, and the mediator also has to be paid. Sometimes if there's a large difference in incomes, the higher earner would pay 100%. Sometimes it's 50-50, 75-25. You can really break it down however you want. So that's kind of the.
Do you generally recommend mediation? Is it I guess it probably depends on the circumstances, whether someone has $2 million between them or, $200,000 between them. But do you generally think mediation is beneficial, or could it be a waste of money sometimes?
So the reason that I generally, not every time, but generally would suggest mediation isn't always with the goal of a complete and total resolution. That's the goal. You go in so that no more attorney's fees, no trial, close the case. But sometimes you just can't get there, and when I can't get there, a lot of times I'll try to focus either on the assets and liabilities or the children's issues. If we are totally not agreeing, for example, on children's issues, I'll say, listen, that has to be saved for court. That's fine. We're, kind of having a good conversation about assets and liabilities. Let's focus there and limit the trial issues, because you're going to reduce your attorney's fees, discovery, the time it takes to resolve the entire matter if you reduce what you need to try in the case.
And you might even figure out that if you can resolve and come to terms on one matter, maybe you can on another. I don't know if we're going into this on the latter questions, and if we are, you can ignore this question for now. But what's the difference between mediation and collaborative divorce?
Great question. I don't think that's in the webinar. I don't remember being asked that. So collaborative divorce essentially is you don't litigate the matter in the traditional sense. So you're not filing requests from one another for financial documentation or other things. It's essentially two attorneys that have been trained collaboratively. You have a financial neutral and a mental health neutral, meaning they're not there for either spouse. And essentially, rather than the traditional litigation method where you're gathering documentation, maybe, not disclosing everything right away until they ask for it, that type of strategy, it's more like we put everything on the table, all of the financial matters, everything, and we try to collaboratively resolve everything. And the parties have to sign a document saying that, they're not going to litigate, that they're going to try to work it out collaboratively. And if the collaboration fails, then each party actually has to hire new counsel to file with the court.
What are your thoughts on collaborative divorce as a general matter?
I have participated in collaborative cases before. I'm not personally trained collaboratively. It's something I've thought about, but it can get expensive, and something that I really try to do is keep my costs down when I can. I can see the benefit, but I personally try to act collaboratively until somebody's not being cool anymore. And then I like the option that it's not a big deal. Let's just ask for discovery. Let's litigate. Let's do what we need to do.
So you're polite and nice until it's time not to be polite and nice?
Absolutely. I mean, I really do try to be. I try for the sake of my clients to be nice with opposing counsel, but if they're going to be rude, let's get rude.
All right. Well, I'm sure even when you're in a fight with opposing counsel, you're still probably relatively nice and respectful.
Most certainly in writing. Thank you.
Yeah. All right. Number 3, we'll keep moving. Child support and spousal support was set 3 years ago. Since then, I know my ex has earned a promotion, but he or she is refusing to provide me with more support. What can I do?
So the thing about spousal support is that it's different than child support in that child support is always modifiable so long as that is relevant child support, whether that be until 18, graduation, if there are special circumstances that require past 18. So long as there's an obligation under the statute to owe child support, it's modifiable. So regarding that promotion, you could do some discovery requests, ask directly from the party. If they're not providing documentation, third-party subpoena to the employer, asking for the documentation, demonstrating their new income. You put it into the calculator, and it gives you the new child support amount. Now, spousal support is something that's not always modifiable, and it is specific to what you put in your agreement, or if you go to trial, what's in your trial order after you do that. So, for example, you can agree and sign off on it being non-modifiable waiving it here, now, and forever at any time in the future, slamming that door closed. But without particular language demonstrating that both parties are signing this freely, voluntarily, understanding what they're waiving, there's some special lingo. Without that, just putting an amount and duration, then you really leave the door open to modify the amount and the duration. So it's really, really important to not sign anything before you talk to a lawyer, because, people put things together themselves trying to save money. I'll pay you X amount, and you both sign it. Well, it doesn't say how long. It doesn't say it's non-modifiable with other language. It can be way more expensive later to involve an attorney than it would be just to have one prepare your documents.
And I imagine it's a difficult decision whether or not you want to have modifiable spousal support. Really depends on the circumstances. There are tons of variables. How much money you have now, whether someone's going to keep earning more money, whether one spouse is going to go back to work, get remarried, whatever it is. All right, well, let's keep going. Number 4, I'm the sole breadwinner in the relationship and my spouse doesn't work. I'm worried that they'll be seeking a ton of alimony and that I will just be working hard to pay the bills. Can I quit my job or go work at a lesser paying job to avoid paying so much spousal support?
This really is a hot topic. And I actually just attended a virtual CLE from Fairfax Bar Association on this matter, because, the case law just continues to demonstrate that somebody that owes either spousal support or child support becoming voluntarily unemployed or voluntarily underemployed, you will most likely be imputed back to your higher salary.
Now, what does it mean imputed back to your higher salary?
So for purposes of determining child support, for example, rather than, hey, I have a pay stub saying I'm making 1/8 of what I was making 6 months ago, if it's determined that your lesser job, that the money that you're earning now is due to you purposely becoming unemployed or underemployed, they can impute you back to that 8 times higher amount.
So you're an executive at a big company making $200,000 a year, and then you start working at a restaurant or at a supermarket making $15 an hour. They might say you're still making the $200,000 as an executive.
Yes, and even if you don't have the money in the bank because you're not making it anymore, you could be obligated to pay as if you were making more. So don't do it, people. Just don't do it.
All right. Although I'm sure it's frustrating sometimes to have to just pay that money. Well, that's why you also need Joanna to negotiate child support and spousal support for you. Although I guess child support awfully is very formulaic. But we can get into that in a minute.
Everything is, you can discuss everything.
Yes. All right, number 5. I want my child to continue doing virtual learning, and my ex wants the child to go physically to school, even though we still have the option for virtual learning. This is not as hot an issue now as it was perhaps several months ago, but it's still out there. What are my options? Another question could be, my child, I want my child who's 7 years old to get a vaccine. My spouse does not want them to get vaccinated. What can we do?
And I think, I remember when we put this together, and this was such a hot, the idea that it's still going on. But, I really go on this question, the way I'll respond is I really go back to what we said in the very beginning about the language in your agreement is so important. Because if you have so many details, things that you're not even thinking about right now, in the agreement. So even like a tiebreaker paragraph that says when it comes to like educational, medical, things like that, if the parties don't agree, maybe it'll say something like you'll mediate before you file with the court, or, deciding which parent would have the decision-making power. Things like that can really empower you and keep you out of going back to court and back to court and back to court every time a disagreement comes up.
Okay. So what do you do in the circumstance? I guess, what happens if you don't have a good marital separation agreement? And I know that's, one of your things, that your marital separation agreement should be 50 pages and it should deal with every eventuality from kindergarten through college. But what happens if you don't have that? I guess
Yeah, my agreements are long.
Yeah, I mean,
So yeah, you would have, if there's a mediation clause, you would have to mediate. But if not, you'd have to bring the issue to court, and you'd probably need a lot of experts and evidence and witnesses, and specific to your child, if anyone is high risk, and have you had COVID before, and what are the precautions the school's taking? It can be a big thing. And at the end of the day, no matter what evidence you present, in that case, it's going to be up to the judge. So if they have certain feelings about how it should go, it might not even matter the evidence that you present, to be honest.
the judge is just going to do what he or she thinks is in the best interest of the child. So by not having a good marital separation agreement, you could end up paying, tens of thousands of dollars. All right. It's interesting. I wonder if there have been, I'm sure there have been disputes, and I assume maybe they haven't gotten to the court yet, as to vaccination status of children. And whether or not, if the parents disagree, how that's being resolved. That'll be an interesting issue to follow, as a side note. All right, number 6. I quit my job 3 years ago when I had my first child and have been a stay-at-home parent ever since, with no income for that period of time. My wealthy spouse has now filed for divorce, but I have no money for an attorney. Is there any way I can have my ex contribute or totally pay for my attorney's fees? And if the spouse shuts down our joint bank accounts and threatens to stop paying the mortgage or car payments, what can I do?
So there is something that you can file called pendente lite or pendente lite motion, and that can be either for temporary alimony, child support, attorney's fees, and it's something that you can request of the court on a temporary basis prior to the final order and the final decision, just in the meantime, to make sure that you are getting the support that you need for bills that are coming.
Now, I guess what's determinative in this question is that it says, my wealthy spouse has now filed for divorce. What happens, this family has 2 children, and before they file for divorce, they need to be separated for a 12-month period in the Commonwealth of Virginia. So what about during that 12 months? So let's change the facts a little bit, and the wealthy spouse moves out and gets a love shack in Old Town Alexandria, and just stops paying for the mortgage, and other costs. Maybe he's still supporting the children, but he says, I'm not paying for your attorney, and you can figure out how to pay the mortgage on the house yourself. The kids can come live with me if they want.
And that's something really that's tricky in Virginia. The separation period, I understand why, it could be beneficial, the 6 months separation if you have no minor children and 12 months if you do. But in other states where you can just file for divorce the day you decide, even if you're living under the same roof, it allows the court to have jurisdiction. So if you need to file this pendente lite motion or seek any other help from the court, they automatically have jurisdiction. Versus here, you really can't file anything until you've filed for divorce, which if these parties just separated and have minor children, it's going to be a long 12 months.
So in this circumstance, the spouse that sort of doesn't have the money and is, trying to figure out what to do, I guess what you would suggest is that he or she talks to you, and we send a letter to that other spouse and perhaps their attorney if they have one, and say, if your client continues with this behavior, we will destroy them in depositions and before the judge, and that they are putting their ex-spouse and children through this. They better reconsider their actions, and hopefully that will cause them to be a bit better.
Yes, I would definitely suggest that type of letter, but I would also suggest my client keep well documented written evidence. So requesting of them saying, I need this amount of money, emails, text messages, whatever they may be, so that when we do finally end up in court, I have a stack of papers I can slam down and say, this is how many times my client requested, this is how many times they were ignored. Here are the overdue bills. We're seeking this repaid, my attorney's fees, and a little bonus. So.
All right. Don't make Joanna mad. All right. Or mistreat her clients. All right. Number 7. I believe my spouse is cheating. Does it matter when it comes to filing for divorce here in Virginia?
So adultery is actually something that is taken into consideration when you'd be filing for divorce in Virginia. It's something that's difficult to prove because you need clear and convincing evidence of a relationship that's sexual in nature. So getting that evidence can be a little bit tricky, but you know,
What does
that's why I
that
always.
mean? Does that mean, can you have a private investigator take a picture of them going into a hotel room together and 2 hours later they leave the hotel room together? Or do you need to have more evidence than that?
I mean, I would say having that, and if you have any witnesses that have observed so that they can testify rather than hearsay, say, I observed, this is what I saw, this is what I noticed. Those are all things that typically can back up that claim, but it can get pretty nasty.
Now, and what's the advantage? So it's hard to prove and may not be worth it oftentimes, but if you can prove it, you don't have to pay spousal support, correct?
Absolutely. So that's something that, based upon the evidence that you might be able to demonstrate to the court, it could definitely be something that, even if you are not successful, might very well be worth it.
And you can always use it as a negotiating tool also. So oftentimes during that separation period then, right, do you have the same rules during the separation period? So would it be considered cheating, infidelity, adultery under the Virginia statutes if someone is cheating during that separation period, or is that different?
The date of separation really is the date that we look to. So up until that date of separation, is there a third party involved?
Okay, gotcha. That makes sense, because I imagine, once there's that date of separation, some folks probably go wild. All right. Number 8. My boyfriend and I have been living together for the last 15 years. We have joint bank accounts. We bought a house together. When we bought the house, since I had bad credit, we put it in his name alone. The mortgage is also in his sole name. I've stopped working. I have been taking care of our minor child that we share together. And we've never gotten married and are not currently married. Will I qualify for spousal support? And what about the joint property?
So in order to qualify for spousal support, you have to be a spouse, meaning you have to be married. And in Virginia, we don't recognize common law marriage. Is that what?
Yes.
I'm scared not to say commonwealth. I almost said commonwealth marriage. Okay. We don't recognize common law marriage. So essentially, other states would say if you have represented yourself as husband and wife for a specific amount of time, if you live together, if you go on vacations together, etc., families have merged, they'd say, okay, you didn't actually get married, but you might be entitled to some sort of spousal support. Virginia, nope. If you are not actually legally married to someone, then you would not even qualify for spousal support, period. As well as this joint property, unfortunately, that might be a civil action that you might need to look into. But as far as divorce court, because you were not married, the court does not have jurisdiction to hear about joint property. But because you share a child together, the juvenile and domestic relations court would be able to hear, even though you were unmarried, regarding potential child support obligation.
Okay, so yes to child support, no to spousal support. So be careful if you're just shacking up with someone. And for the joint house, you'd probably have to contact one of our other attorneys here in the firm to perhaps file a lawsuit for, I don't know, it wouldn't be partition because there's not joint ownership. Maybe there's unjust enrichment, maybe there's equity claims. You'd have to look into that on the case. So the point is, I guess, be careful when you're just living with someone, what you do in that regard.
And it's really common for people in their 20s and 30s, I've seen, to just live together, buy a house together, even if it's jointly titled, different than that question. So definitely reaching out, whether it's me or, one of our civil attorneys that can maybe prepare a document should things go sideways, is very, very important.
And is there anything that you can put into place, if you're just living together, you can't make it marriage. So, it's not really a prenup agreement. I guess you could just enter an agreement, but, you won't have the protection of, marriage and all the rights that comes with it, at least in Virginia. So, all right. Number 9, my husband and I have been divorced for the last 3 years. He has a job with a large government contractor, which happens here in the DC area. Or it could be she has a job with a government contractor. But in this scenario, the husband's been offered a great job in San Diego, which would nearly double his annual income. We live here and we're divorced in Fairfax County. He's remarried. I'm not remarried. I do not want him to move with our child. Is there anything I can do to stop him?
So and
they have joint custody. So okay. Let's just make that clear.
Yes. So essentially, because they have joint custody, if one party wants to move that far, there's a statute that governs the amount of miles. And if they want to move more than 50 miles, then they need to request that of the court via a relocation petition, essentially, and get the other party, the non-moving party, served. Once the non-moving party is served, they have a certain amount of time to file with the court if they object. And once that objection has been filed, then you basically have a trial. And during that time, you provide evidence, witnesses, exhibits, everything either pro or con for the move. And those are things like school rating, if they have an offer letter, if it's an actual tangible, like a job offer, or just like pie in the sky. Where are the family members of the children located? Is everyone here in Virginia? Is everyone in California? So how heavily involved is the child in extracurricular activities here? Are you just totally uprooting them? So many things to consider.
What about the circumstance? I could see this as being incredibly unfair, where one spouse is making $500,000 a year and wants to, relocate to San Diego. The other spouse is making $75,000 a year and doesn't have the same resources, and there's potential trial. Would the spouse making $75,000 a year have to pay for their own legal fees, or could they ask for help from the wealthier spouse? Because it almost seems as though they could get bulldozed.
Typically, you don't get your attorney's fees back, because this is not something that is arising out of like a bad faith type of thing. If someone wants to move, it's not the same as, they're not returning the child at the time that is written that they're supposed to. Yeah. You can certainly ask for it based upon the need of one party and the ability of the other party to pay. But, these trials are very emotional because there's a lot at stake. But really, the preparation is so laser focused. Like, I have a list of like 30 factors that I send to my client, and I say, any evidence that you have either in support of or against. Actually, I typically ask for both. What are they going to throw at us, and what do you have to support your argument? And I go through it with them, and I just try to keep it very focused. So even though relocation trials are a lot of work, they're typically not as expensive as custody trials, because there aren't as many, things to consider. It's just best interest of the child. Here are factors, present it, and then the judge just decides.
Is there any preference that the child does not move from the location where the divorce occurred? So in other words, does the moving spouse have sort of a bit of an uphill struggle? Or is it really 50-50, purely best interest of the child?
I have seen it ruled upon every which way. I will say, though, if there are at least a few, like 2 or 3 family members where the child currently resides, even if there's a large group somewhere else, and the child is 7, 8, not like 3, 4, just has made some friends and is involved in extracurricular activities, typically I'd say the courts try not to uproot children.
Interesting. All right, number 10. My 12-year-old daughter has indicated she doesn't want to stay with her father this summer or even on his assigned time. No signs of abuse, just a 12-year-old who said they want to spend more time with mom. So dad's a fine person, just the 12-year-old wants to spend more time with mom. What can you do in that circumstance?
This is a really hard thing, and that's why we clarified at the beginning too about this being particular to Virginia, because, for example, in Maryland, they have something different than Virginia, which says at age 16, a child is able to petition to the court and, have their voice heard from them if they want to. Versus here in Virginia, we really try to keep the children out of it. And that's not something that's written here about, a 16-year-old being able to do it. So what I would suggest to this person is whatever is ordered, try to abide by that, make your best efforts and just try to follow what's ordered, because if what's ordered is not followed, somebody's going to be held in contempt.
And make sure you document the heck out of it. Call your attorney, be supportive to your daughter in this circumstance. And I think, we've dealt with these situations before. You almost send an email to the father and say, I'm actively encouraging her so we comply with the, marital separation agreement and custodial arrangements, but I can't force her. And I'm not sure you want to force her either. What ideas do you have? Because if the one spouse, the mother just sort of says, no, go to hell, we're not going to do this, you could potentially open up to a show cause order where the police could get involved, which obviously you want to not happen in the circumstance or any circumstance. All right. I got divorced 14 years ago when kids were in kindergarten. Now they're in sports, summer camps, orthodontist appointments, etc. Our marital separation agreement doesn't deal with these issues, and my ex and I cannot agree on anything. What do we do besides be very mad at the attorney you used then?
Yeah, what do you do? What you should have done is call me first so that we wouldn't be here. But here we are. It happens all the time. This is not something, if you have this issue, don't feel bad. I see it all the time. But essentially, if your agreement does not specifically indicate the percentage of responsibility, then if the other party is not contributing their portion to you, you likely will either have to do an addendum to the agreement or, renegotiate terms, but it can get, difficult because if you don't have any guiding terms. And what I always put in my agreements too, as a tip for everybody, is don't just put 50-50, I do the 30-30 rule for myself. I made that up. I don't know if that's a thing, but essentially I say, like, within 30 days of the expense being incurred, the payor sends the documentation to the other party. The other party in turn has 30 days to reimburse. So that way it discourages someone saying, oh, here's 15 years of receipts, I need 50% back. And also it gets that reimbursement going. And if someone fails to do it a few times, you got what you need for a show cause. Let's go. It's relevant. It's now.
And your agreements do allow for offsets. So if someone does not do a reimbursement that they should have, can you have an offset for spousal support or child support that would otherwise be owed?
I've done offsets, but the problem that I've run into with offsets is that people don't always calculate correctly, and then it really just snowballs. So due to that, I really just try to keep, if there's an alimony or child support obligation, that number clean and then deal with things separately.
Now, what about going back to number 11, where the kids were in kindergarten, so that means that they were, 4 or 5 years old? I should probably know that. My kids aren't that far from that age. But now they're, 8 or 9, they're doing soccer and baseball and scouts and everything else. And one spouse, it just says, no. My obligation is to, have, Fridays from 5 to Monday morning, and then every other Wednesday, I'm not taking them to scouts. I'm not doing baseball. I'm not paying for the orthodontist. I'm not putting money in a 529 plan. What do you do in that circumstance?
So typically that's why I try to be as specific as possible. So for example, extracurriculars are really the one that gets tricky. So because, if both parties don't agree to the particular extracurricular, what I usually write, which isn't always the best thing, but it's the best that I've come up with over the years, essentially just says that the parties will work together to agree. And because of that, whoever has the minor child during that activity, they're responsible for taking the child. And should one party not agree to the extracurricular activity, that they would not be responsible for 50%, but that the other parent could pick the child up and take them, or the non-paying, non-agreeing party would be required to take the child even though they wouldn't be financially responsible. Those are things that I have to talk to with my client.
What if we don't have an agreement though? What if we find ourselves, the child's 8 years old and there's no agreement that deals with it?
Then there is no overarching equal responsibility.
Can you go to the court and say, my spouse isn't cooperating with summer camps?
You certainly can, and you can request not only for back reimbursement, but also moving forward for the court to issue an order going forward, so that it's not every summer or every school year you're going back and back and back.
But there has to be some sort of obligation. Again, we've had other clients who have had situations, and I've heard of this, where one spouse wants the child to go to a summer camp, and the other spouse says, no, they can just come to my house and hang out all day. There's a swimming pool in my community. And the other spouse says, well, that might not be very good for them all summer. Let's have them go to summer camp. Let's split the cost. And the other spouse says, no. I think what I've seen in that circumstance a few times is, if you want the kid to go to summer camp, you're paying for it.
And it has to be on your time with the child. That's the other thing to consider.
All right, well, let's keep moving. I think we're doing okay with time. Maybe we're a little bit behind.
I love to talk about this stuff, so you gotta hurry me up.
My fiance proposed to me last week, and this week I was provided a prenuptial agreement. I'm hurt and confused. What should I do?
So prenuptial agreements are so much more popular now than they were in years past. And I think it's a great tool even if you don't have 10 beach houses and all these assets. It's really just an opportunity to decide with your spouse, should you go forward with divorce at any time in the future, whatever you feel is fair. You can write it down, and if you ever did get a divorce, that is what would be followed, not the law of whatever state you're getting divorced in.
So oftentimes you see it though, where one spouse comes from a wealthy family, or perhaps an entrepreneur who, it's Bill Gates with Microsoft before it goes public, or whatever it is, has significant assets. And the other spouse or the fiance thinks it's, well, this is so unfair. You're planning for divorce. What do you say in that circumstance?
I mean, it's tough, but Merritt, on these webinars too, we've talked a lot about, for example, commingling of assets and the things that happen to separate property, premarital property, how it can be converted to marital property, sometimes accidentally, sometimes purposely. And if there is someone with a lot of money that they earned before meeting their spouse, and both parties agree that that money should be considered separate, whether or not they contribute to a house, put some of the money into a non-marital account, things like that, a prenuptial agreement could just clean up what Virginia law would say later might be considered marital, and the parties could say, okay, it's non-marital.
Okay, very good. So if someone comes to you with a prenup, you can talk them through it and say it's not necessarily the end of the world. All right. I'm currently divorced. My ex is required to pay a certain percentage for uncovered medical, dental, and extracurricular activities for a minor child refusing to pay. What can I do? We've sort of talked about this quickly. So
we did. So essentially, like I said, I like to use my 30-30 rule. So if somebody is continuing to fail to reimburse as the time is required, it makes my job so easy if the agreement says that. Pursuant to paragraph 3A, the payor spouse is to give the receipt within 30 days, the other, ex-spouse is to pay back, and within 30 days thereafter, on this date, this date, this date, this date, the requests were made, never reimbursed, the amount is this, we're asking for this in attorney's fees because we had to file this based upon their non-compliance. That sounds like a winner to me.
All right, chicken dinner. All right, number 16. I've been married for 50 years. I've been working for my entire marriage. I have a significant retirement account and want to know what's going to happen to it if I get divorced. And the spouse does not have the same sort of retirement accounts.
This is something that I've seen quite often. Honestly, people that have been married for a long time like that has been coming up recently. And essentially, the court wants a statement from the date of marriage with the amount, and then as close to date of trial, not date of separation. With this particular instance with retirement accounts, the courts have said that they like it closest to trial, closest to the amount, as of now. And essentially the amount in between, the current amount minus any premarital funds, 50% of that minus plus and minus gains and losses would be the other spouse's.
And the other spouse can get it as a retirement account. What's the fancy term for it?
It's so funny. So it's Quadro, Q-D-R-O. Us lawyers and our acronyms, I'm telling you. So it's a qualified domestic relations order, and it's something that's prepared specifically indicating what funds from the retirement account should be transferred to the other party's retirement account. And it is a non-taxable event. That Quadro is actually signed off by the judge in the divorce case. And so essentially, so long as they're both the same type of retirement account, it's a non-taxable event. However, if the recipient spouse or even the spouse that had the funds take out money, you definitely need to talk to a financial planner or a CPA that knows regarding taxes and what's smart to do.
And just very quickly, I know that there are also special rules for military pensions. I think we recently wrote an article that's on our website on this. There's some recent Virginia cases on this. Any sort of, in one sentence or two, sort of special rules as it relates to military pensions and retiree benefits?
I would say every situation is different, and that you definitely should consult with an attorney before making any decisions, before withdrawing funds, before getting information will empower you to make the best decision possible.
Exactly. And as I recall, there might be differences between someone from the military's benefits related to a disability compared to just other sort of retirement benefits. So again, you talk to someone who's a specialist in the area. And I think Joanne's worked with a number of folks in that circumstance. All right, number 17. I think we're back on track. I haven't been served with the divorce papers yet, but I know they're coming. We share children together, and I truly believe the kids should spend more time with me. I know this is going to be a custody battle, and I'm guessing things are going to get ugly. What are some of the things that the court looks at when determining custody, so I can start preparing?
So something that I like to suggest to people that know divorce is coming, that custody is going to be an issue, is to either electronically, like on your phone, or a Word document, your calendar, some type of journal, even just jotting it down with the date, the approximate time, and if there's an instance, an event that occurs, that would help you. So essentially, we're getting around some hearsay issues by you being able to, if you're on the stand, you can reference your notebook and say, things that you observed, that you heard, things like that would help. So when it comes to the minor child or minor children and the other party, just things that would support your claim as to why you think it's best for the child or children to be with you.
And I guess what you're looking for there is all the evidence you can. So another thing is just sending emails to yourself. And it's, Monday, I was the one that picked up the child. I took them, made dinner. I put them to bed, and said goodnight to them. Tuesday, I took them to school. Dad left the house, we're at 6:30, or dad missed his, time where he was supposed to pick up from school, et cetera, et cetera. So it's just documenting every single circumstance. Because again, the court's going to look at all of that and determining best interest of the child. All right, number 18. My spouse is very sneaky and untrustworthy. I've always liked this question. And I just know he or she is hiding assets. I never had access to financial information during our marriage. And I'm afraid aren't going to give up all of the financial information, and I won't receive my full share. What can be done?
This is when the discovery process becomes your best friend. So there are so many avenues in which you can, through the courts, request documentation, and it's required to be provided to you in a certain amount of time. If somebody files an objection, then you go to court and you have a hearing, and the objecting party has to demonstrate to the court why it's not relevant, or it's overly burdensome, things like that. But I've been pretty creative over the years in how I can get financial documentation. You can do requests directly to the party. You can, if you know what banking institutions, financial institutions that they're with, you can do third-party subpoenas requesting straight from those banking institutions. You can request third-party documentation from their employer. You can depose their grandma. You can do a lot of things. And it does become expensive, but if you're spending money on just like a fraction of what you might be entitled to, that you're fairly certain is out there and they're hiding, a lot of times it really can be worth it.
Mm-hmm. Very good. All right, number 19 is, we've been divorced for 3 years. My ex is remarried, and their new spouse is very successful, makes a ton of money, and they've moved into a new house, fancy new cars, and the spouse is refusing to pay any additional child support or spousal support that was previously ordered. I'm mad. I want more money. What can we do?
I mean, this is another really sticky one that was also included in the recent CLE continuing legal education course I went to, because new case law is coming out all the time on this issue, because currently the courts say that the new spouse's income of your ex is not something that should be considered in the calculation of child support. And, it's a hot topic. If somebody was rolling up in a beat up car before and now is pulling up in a Ferrari and, is in this mansion, it just doesn't seem fair that their obligation would not increase. But currently the case law says that the new wealthy spouse income is not considered. Now, when it comes to spousal support, I point you back to the beginning of the webinar when we were talking about if it's modifiable or not. Because if it is modifiable, then you might be able to try to petition the court to modify it based upon, if they have the accounts that they have access to. But for purposes of child support, it's really about the monthly income, and it's plugged into a calculator.
Can you impute some income to the spouse, perhaps? So they used to pay $4,000 a month for rent and a car payment, and they don't do that anymore. They used to pay for groceries, and they don't do that anymore. So could at least some of that be imputed for child support purposes?
So the courts have said that they could call those in-kind payments. So those car payment, rent, mortgage, things like that are now being paid from someone else, that could be considered in kind. So that $4,000 that the child support obligation person is not paying could be added to their income. But it gets really tricky, and a lot of the judges just don't really follow that, to be honest.
Gotcha. All right, and on to number 20. I'm going through a divorce, and my spouse and I purchased a gorgeous piece of artwork on a trip during the marriage. We both want to keep it. I know this is going to be a battle until the end. Help, Joanna.
Well, art is very important. My sister is an art consultant, has been in the art world forever and ever. So art is very important, as my Z gallery thing is behind me. Don't tell her. No. But really, though, what I encourage people to do, if there is a particular asset that both parties want and nobody's budging, You know, we go back to the mediation question. If we're able to resolve everything except for repainting, your trial costs are going to be a lot less than if we're talking about the house and the cars and the debt. So focusing in on this question, I encourage people to make a list of assets and liabilities, which I'm happy to do if you provide me with the information, demonstrating their approximate value and, you know, possible distribution. And, you know, if we determine the value of the item, sometimes people just want to be bought out and say, give me X amount of money and you can keep the artwork. Is that worth it to you? You know, you have to decide. Maybe you need to get competing appraisals. Maybe one person says, oh, this is junk, $50. Somebody else says it's worth $10 million. You know, then you need to get competing appraisals, get those people to testify, bring it to court. But I will say in these situations, a lot of times the judge I've seen will say, just sell it and split the money. So nobody's really happy. So
What
I would
happens
say,
if it's not something that can be sold? It's the family dog.
I've litigated about dogs before. That's tough too. A lot of times it just ends up being like a child and there's custody and it's like every other week, the other party, you know, and some Christmases have to be at so-and-so's house. So, you know, that can get a little crazy.
I've never heard that before. Wow. I don't know if that's good or bad for the dog.
Full service here, ready to help with your needs.
Yeah. Has a couple ever fought about a cat or other types of animals, or is it really just dogs?
I personally have only litigated dogs, but you know, I'm sure snakes and other weird pets.
I guess I don't want to offend anyone that likes birds. I was going to say I can't imagine anyone litigates about birds.
I preferred as a child a parakeet. I would have fought for the bird.
Well, I think with that brings us to the end, and it is 12:57, so we timed this perfectly. Joanne, do you have sort of final thoughts?
Well, I just want to thank you, Merritt, so much for presenting with me, and thank everybody that joined in today. Like we said in the beginning, if you have any questions, if we didn't cover a topic that you'd like to hear about the next time we do a webinar, please feel free to email me. My email's there at the bottom. You know, email Merritt, whatever it is. We're happy to discuss it. If you'd like a more private conversation, I'm happy to chat with you. We are providing complimentary consultations if you mention that you joined in the webinar. And we really enjoy these. I love that we're able to do these webinars at no cost. We have so much information and so many resources on our website just to empower people, because you know, family law matters are extremely personal and emotional, and whatever we can do to help, we want to do it.
Great. All right. Well, with that, thank you, everyone. Thank you, Joanna, and goodbye and take care.